Thank you.
Mr. Kelly, good morning. You have 10 minutes.
I know that, so I'll speak quickly. Thank you, Your Honor. As you know, this is an appeal from a denial by the single justice for a petition to transfer an appeal from a Board of Registration suspension for Mr. Hamel, who was a funeral director. Before we start, I do want to acknowledge three things right off the bat. First, we acknowledge, of course, that the single justice's power to transfer is discretionary. Second, the board's decision to suspend Mr. Hamel did include the right to appeal, a notice of the right to appeal, and it did specifically note Mass General Law, Chapter 112, Section 64. So there's no issue as in that Gurry case where he didn't know. And third, the November 22nd, 2005 complaint for judicial review of the board was incorrectly brought by Mr. Hamel's prior counsel in the Norfolk Superior Court.
What do you do with the Friedman case?
Okay, now, thank you, Your Honor. The Friedman case is, as you know, stands for the proposition that there is no tolling of the statute if you incorrectly bring the appeal, if you will, to the Superior Court. However, as in my brief, I've stated that we assert that there's a distinction in the fact that we are not asking for an extension here. We're asking for a transfer. And the distinction comes in the way that the Friedman case transpired. This was a case that was actually dismissed by the Superior Court before it was brought up to a petition to the Supreme Judicial Review. And the difference is, and this is what, and I have to, my sister counsel and I, when we agreed to stay at the Superior Court, and much to her credit, she acknowledged that if we don't stay the Superior Court case, we have nothing to transfer. That's the case that happened in Friedman. There was nothing left to transfer. It was already gone. The only way they could have breathed new life into it is to give him an extension.
But how does that equate with an abuse of discretion by the single justice? I mean, if he had allowed it and transferred it, then fine, you probably would be, here correctly.
Well,
but if, on the other hand, if he says, no, I'm not going to do it, how is that an abuse of discretion?
Well, again, and of course I understand I'm treading lightly here, but I would suggest not so much a direct abuse of discretion, but the single justice had stated in a footnote in his denial, because at one point I had mentioned in the brief that there were other cases in which there had been a transfer. And the single justice had stated that based on the Friedman case, of course, came after all those cases. And the point that I would ask the court to consider, and the single justice even, is that I don't believe that necessarily precludes any transfers. I think it was an error on the part of the single justice to.
So you're saying that your reading of the single justice's orders, that the single justice proceeded on the assumption that he was bound by Friedman.
Correct.
And therefore he was not exercising his discretion, which we can therefore decide is not an abuse of discretion.
Correct,
He thought
Your
he didn't
Honor,
have
because,
the discretion.
I mean, these cases have been transferred before. So there is a distinction between a transfer and an extension. And Friedman, I assert to you, only says that there's no tolling. And again, I totally agree. There is no tolling in the statute. We're not looking for an extension. We're looking for a transfer. And whereas...
But Friedman is pretty explicit on the point. It says we don't care about what went on before. Filing it in the wrong court doesn't toll the 30-day time.
To file it here.
Well, I understand that.
It's flat out categorical.
That was the only way they could, in Friedman, that was the only way they could get back into this case. It was gone. Because once he had filed all everything in the Superior Court and it was dismissed, there was really nothing to transfer. We still have life in this case. There's still a heartbeat here to move up. And I suggest to you, as I did in my brief, it's analogous to the couple of rules in appellate procedure where we are allowed to take a mistake where there's still life beating and reach something on the merits as opposed to losing it on a procedural basis, strictly, namely Appellate Rule 4, in which if someone brings something in the appeals court and it's supposed to bring it in the trial court, it's noted, timely, and sent to the right place. Also, Rule 10C, in which if somebody messes something up as far as Rule 9 and Rule 10 and not prosecuting the appeal properly, there's that mechanism that even if the other side comes and files a motion to dismiss, as long as it's cured beforehand, it's allowed to be brought up on the merits.
But does the Friedman case stand for the proposition that the Arthurs and Feldstein cases are no longer good law?
I don't believe so, Your Honor, because those cases were transferred. And
but that's why I say, is Friedman say that those cases are no longer good law?
It does not say that, and I would suggest to you, Your Honor, that the fact that those cases were transferred over, and there was not a situation where they were lost beforehand, as in the Friedman case.
Well, now we get to the heart of Justice Cordy's ruling, right? It's not, I mean, I understand why at first blush it may have looked as if he didn't think that he had the discretion, but his footnote 2 goes into those cases.
Right.
And as I read footnote 2 of Justice Cordy, it seems to me that he was saying, he lists the cases that you drew to his attention and then says all of the transfers occurred long prior to the court's decision in Friedman. He doesn't go so far as to say they were overturned.
Right.
But continuing that this court has repeatedly made it clear for decades that the petition must be filed in the SJC. So if he's saying in the exercise of my discretion, I could transfer it, but I'm really not going to transfer it because Friedman has made clear where you should file, why is it an abuse of discretion for him to have reached that result?
Well, in answer to that, Your Honor, I would ask that you note another case that was cited in my brief, Constantopoulos versus Whately, in which a similar type situation arose where they brought this thing to a probate court, and bottom line was this court basically came down and said you didn't have any right to bring that in the probate court just because it involves equity. There's still a limitation. But what the court did say, or this court did say in that case, is that because of the seriousness of the nature, and I would suggest to you, Your Honor, if we were talking about a criminal case here, which a liberty interest was involved, the court would be much more favorable to allow this thing to go.
But all these cases fit into particular slots, and criminal fits into a slot that's pretty big because of jail time.
Right.
Now, this man is losing his license for 2 years, which is important.
Yes.
But there is Friedman out there for a long time, a long, long time.
Well, and again, all I can suggest to you, Your Honor, is that Friedman is clearly distinguishable in the fact that
I mean,
there's
I
nothing
think
left.
it's more than a discretion issue. I think it's a question of error of law. By the time he asked for the transfer, had the 30 days expired?
Oh my gosh, yes. I mean,
Yes.
I took this case
So-
over. But the thing was that there was no prejudice involved in this case either, because the board, I mean, they submitted their administrative record. They, along with their motion to dismiss, they also submitted the opposition to it. Essentially, it's all done. There's no prejudice involved
Well,
here.
I know it, but Friedman is, there it is.
And again,
It's like the
I'm
Rock of
distinguishing-
Gibraltar, and he sailed right into it.
I'm trying to just, and apparently that's pretty common. The footnote in the Mass Practice series says it's not uncommon for lawyers to do that. Not that I'm making excuses, but apparently that is something. And what I'm basically asking the court to do is just to recognize that it is something, and recognize that there is a property interest involved here. There's the livelihood interest that's involved. Analogous to, but not, as you said, Justice Green, not to the same level of liberty interest.
I
but
understand.
still,
I understand.
It's
It's
a
an
serious,
important.
It's a serious.
It's like a
interest.
lawyer
In fact,
discipline.
There was no
Harm.
yes. then I would suggest that is our consideration. I see I've got like 12 seconds left, so unless the court has any other questions, I'll rest on the brief.
Thank you,
Thank you,
Mr. Kelly. Ms. Martin-Reynolds?
Good morning, Your Honors. Assistant Attorney General Mary Ann Martin for the Board. As was mentioned already this morning, the Board notified Mr. Hamel of his right to appeal within 30 days under Section 64.
Oh, he concedes that everything went right from the
Yes.
board standpoint, all his notices, everything else. So it's basically the Friedman case, and the Friedman case flat out says, after 30 days, forget about it, doesn't it?
Yes, it does. And in
Did
that,
he was the action commenced in the Superior Court within 30 days?
yes,
So isn't the problem here that the Friedman case says forget about it, but the facts are somewhat distinguishable. So you have a lawyer who doesn't really know what the law is.
on that point, if I may, and then we could continue. This court recently affirmed in the case of David Maitland versus the Board of Registration in Medicine. That was a rescript opinion that came out after my brief was filed. It came out in January of this year. Errors of counsel in filing in the wrong court are not going to protect a license
Well,
holder.
the notice, if he looked at the statute, the notice said, look at 11264, and it says right there in the Supreme Judicial Court.
Agreed. And
So we have a malpractice action.
Possibly.
that's beyond.
So,
Then the question is going to come up, and I didn't raise it, just flippantly. Then the question is going to come up as to whether any attorney would understand that he was absolutely precluded by the Friedman decision from filing in Superior Court. I don't know what the answer to that is. The single justice did not say that Friedman overturned those earlier cases, correct?
Correct. Friedman is good law. The earlier cases, the Gurry case, there was an incorrect notice where the board, the administrative agency in that case had actually directed the party to the Superior Court. That was an appropriate case for transfer, given that there was an incorrect notice, affirmatively incorrect notice. In this case, Mr. Hamel was directed to file in this court. He didn't do it. He only became aware or only acknowledged that he should have filed in this court when we filed our motion in the Superior Court. Our motion in Superior Court presented two theories. One was that the court lacked jurisdiction, and the other was we addressed the merits of the case. That motion was completely timely under 12H, where we can raise subject matter jurisdiction at any time. This court has been very clear in a number of cases that the time and place of filing required in statutes or jurisdictional requirements. Mr. Hamel is trying to use the transfer statute in a way that's inconsistent with well-established case law.
so that under the transfer statute, the transfer itself would have to occur within the 30 days.
Yes, we would agree that if they had filed a petition to transfer to this court within the original 30 days, then that would.
Well, sure,
The
that's
filing
it.
of the petition or the allowance or the actual transfer?
I would accept the filing, given that that he would not have control over when the petition was acted upon.
Which petition?
If Mr. Hamel had filed a petition to transfer his Superior Court action to the single justice within the original 30 days,
Why would he do that? Let's assume he realizes that he's made a mistake. Why doesn't he just dismiss the one petition and file here, or minimum file here, file a motion to transfer and consolidate? I mean, the only circumstances that I can think of in which an attorney would do that is if the attorney suddenly figures out he's in the wrong place. And typically what you do is you go make sure that you're in the right place, and then you let the chips fall where they may.
I don't know if there are circumstances where he may benefit by filing a petition to transfer as opposed to just filing his complaint in the
Sure.
with this one. Possibly there's some savings of filing fees.
What date was
Or
your
maybe-
motion to dismiss within the 30 days? No.
No, the board's motion was a motion for judgment on the pleadings, and that was filed in July of '06. So
Long after the 30 days have gone by.
long after the 30 days had
And
gone
at that
by.
point, he files up here.
Right, after we had filed our motion, he basically acknowledged that it was correct.
We've had a few more cases, you've cited one, but we've had a few more since this case arose, where we've applied Friedman to the same effect against doctors and some others,
Yes,
veterinarians, a few others perhaps,
yes, professional license holders.
professional license holders,
Yes.
flat out, we said you can't do it.
No, and it really, it is clear in the case law that, clear in the statute, first of all, it's clear in Section 64 that the filing is to the single justice, to the Supreme Judicial Court. And
It's
that's been-
jurisdictional.
And that's jurisdictional. Following the time and manner of effective filing of an appeal under the statute, he just is simply out of time. And therefore, there was no abuse of discretion in the single justice in denying the petition to transfer.
What's, from the board's point of view, what's the difference between, the dead case in Friedman and the little heartbeat that's still beating away, from Mr. Kelly's, from the board's point of view, are both cases equally dead? I mean, what's the factual circumstance?
Yes, from the board's point, both cases are equally dead insofar as he failed to file within the 30 days before the single justice. He's citing a particular, or trying to take a different road than may have been tried before, but in any event, the result is the same, is that he was untimely and he went to the wrong court. Therefore, we would ask you to affirm the single justice.
Thank you, Ms. Martin.